Okay, page 28. So today we are going to talk about if you're going to be opening a business in another jurisdiction, another country, and some of the ways that we look at business organizations internationally versus how they're treated in the United States. And we're going to start off with this page here, page 28. So this is a list of some of the various different terms that we talk about with a multinational enterprise that are commonly used that discuss different ways that you can structure setting up an organization that has cross-border activities. And these are sort of generalized terms, and then we'll get into a little bit more specifics about LLCs and that kind of thing. So we have parent company, a branch, an agent, a representative office, holding company, a subsidiary, and a joint venture. And again, these are terms that are commonly used when we talk about, you know, if I was going to open and I wanted to start doing business in Dubai, for example. If I'm a US-based corporation and I want to start doing activity there, what are some different methods or ways that I can organize my business structure to participate and take place in Dubai or other countries? So starting off, we have the concept of a parent company. So the idea of a parent company is, when we use that term, that typically relates to the main entity that is at sort of the apex of the organizational structure. So like, for example, Nike, sportswear, shoes, etc. Nike Incorporated, headquartered here in Oregon, is a multinational enterprise. Obviously, they do business all throughout the world. And so the parent company would be Nike Incorporated. And then down below that, they have different various entities or other affiliations that they would use to do both business domestically. So like, for example, here in the United States, Nike has Nike USA Incorporated, and then they have other subsidiaries around the world that all fall under the idea, or fall under the umbrella of the parent company, Nike Incorporated. And so we use that term parent company. What we're referring to, if I can make a little diagram here. So a parent company at the top of the list. And then from there, depending on how you want to structure or what local rules in whatever jurisdiction you're at in the world may dictate how you can establish a presence in another country. It may be a situation where you're going to open up a separately formed entity within that country itself. So we might have Nike of Dubai as a new corporation. Or it may be that because of whatever local laws there are, we need to organize ourselves in some different manner. So these terms that we're going to be discussing are common terms that are used to describe different organizational type structures that we may utilize. So parent company will be at the top. That's the apex company in the organizational structure. So I'm going to go down. I'm going to kind of skip around these a little bit. Next, I want to talk about a subsidiary, the term subsidiary, which we use this term domestically as well. So a subsidiary is going to be right here. When we use the term subsidiary, we're referring to a separately organized and incorporated entity of some type that is owned by the parent company, or perhaps a group of parent companies if it's some kind of a joint venture, which we'll get to in a moment. But the key that I want you to know when we talk about a subsidiary, and the term subsidiary, is it is a separately organized, if it's a corporation, it'll be a separate corporation, or a separate LLC, limited liability company, or some other type of business entity that is permissible under the rules of the jurisdiction where you're going to be located. So it is a separate tax entity, perhaps, or a separate form of a corporation or joint stock company or business trust, depending on what type of allowable entities you have, and that it's owned by the parent company. So here, if we had parent company incorporated, the U.S. company, and if we're going to be setting up in Costa Rica, we would start a separate corporation under Costa Rican law, depending on what the law is there. There may be some restrictions on the ability for us to do that, which we'll talk about in a moment. But the key is, when we talk about the word subsidiary, we mean it is a self-standing entity in and of itself. So if it's a corporation, the equivalent of a corporation in Costa Rica, it would be the stock, the ownership of the subsidiary would be wholly owned and held by the parent company. Now, sort of the opposite of a subsidiary is the term a branch. A branch is a unit or part of a company, but the difference between a branch and a subsidiary is the branch, it's not a separate entity in and of itself. It is simply an offshoot of the parent company that may take the form of an assumed business name or some other type of presence within a location, but it is not a separate corporation or a separate LLC. So it is the parent company itself doing business in that location. So if we're talking about Nike Incorporated, which is the parent company, a branch would be the company itself with a location in that country, page 28. But it is not a separate corporation or separate LLC. It is the parent company itself with a local presence of some type. That could be a storefront or a manufacturing facility. They may use a different name, so they may say Nike of Costa Rica as an assumed business name, but that's just an alternative name to the parent company itself. It is not a separate corporation, so it's a fundamental difference. A subsidiary would be a separate corporation, and the reason why that is significant is the subsidiary would be established and formed under the law of whatever country you're doing your operations. Whereas a branch is just an alter ego of the parent company itself. So we would have the US-based corporation, and if Costa Rican law or wherever we happen to be, Dubai or whatever, allowed for a foreign corporation to do business within that state, it would be a separate presence, but not a separate entity in and of itself. So a branch, here I've got it tied back to the parent corporation itself, but you could also have a branch coming off of the subsidiary. So the subsidiary, for example, separately incorporated maybe under the laws of Costa Rica, and perhaps they would then have other offices tied to the corporation that's set up under Costa Rican law, perhaps in Panama or Nicaragua or other countries that neighbor it, that tie back into that subsidiary. So they're not all necessarily going to be tied directly to the parent company itself. So subsidiary, separately incorporated, it is a separate entity which may be taxable itself. A branch is just an alternative identity for the parent corporation or a subsidiary or a combination of those as an assumed name or other type of presence, but it is not separately organized as a separate entity itself. Okay, so the next, so just to kind of give you an example, we go back to that for a moment. So perhaps we have, let's use Nike. So perhaps they have a whole separate corporation, or perhaps they want to establish different branches, one to do manufacturing, one to do marketing and sales, one that focuses on a specific area of sports, like golf or tennis or whatever. And so they may have different names, like Nike Golf is an assumed business name of Nike Incorporated. So that's what I mean when I say a branch. It could be either a business name or a product line or some other way that you want to organize the business itself. A subsidiary may be utilized, and there may be more than one. This is very common, especially in large corporations. A subsidiary may be established for various different purposes. Maybe you're going to have a factory in a particular country, and you want that factory to be set up under the laws of that country for various reasons, such as minimum participation requirements. And so you also want to, if this is for manufacturing or for product sourcing or for trademarks, holding trademarks and copyrights under the laws of that jurisdiction because there are more favorable taxes. Google does this. They have Irish corporations that hold a lot of their patents and trademarks, and that's the only asset they hold. And the reason for that is there are more favorable laws to be able to hold those intellectual property rights in a separate corporation, and then they either lease them or they tie them back to the parent company through ownership. So I'm kind of talking in very generalized terms. But the idea being a subsidiary is going to be separately organized, have its own incorporation bylaws, organized within the country that you're doing business, whereas a branch is just going to be an alternative name, so to speak, for the parent or the subsidiary. So the next term that we utilize is the term agent. And when we talk about the term agent, we are referring to a contractual relationship with the parent company or a subsidiary with a company or a person that's located within a specific country that will represent or do business on behalf of the parent or a subsidiary. But the agent is their own business in and of itself. And this is usually done for various reasons, such as it may be you want to do business in a country, but the laws of that country may require that a foreign corporation has to work with a local company, that the foreign corporation may not be able to directly do business within a country because laws that prohibit that, or they require a joint participation with a local company or a local person, or perhaps they don't even allow a foreign corporation to do business in that country, and so therefore the only way that you can do business in that country is to enter into a contract with a local company. So perhaps, for example, it might be sales of tennis shoes and sportswear, and if Nike wants to go into a country and sell products, perhaps the laws of that country prohibit a foreign corporation from directly doing business. And so what they would then do is they would find a local company, they would enter into a contract, give that company the rights to utilize the Nike name, to sell the products, and then the local company would be considered an agent. So an independent person or company with authority to act on behalf of the company itself. Or it could, so that could be for sales, it could be for manufacturing. So they would basically give the specifications of the shoes or whatever products they want to the local company, and by contract they would build whatever is wanted product-wise. But the main thing I want you to know, when we use the term agent, we're referring to a completely separate company in and of itself that by a contractual relationship with the parent has the rights to do business, do manufacturing, distribution, warehousing, whatever the case may be, for the parent itself. So it is a separate entity, separate ownership, and the affiliation is that of a contractual relationship, is basically a contractor or a subcontractor, depending on the type of business. So a branch is an alternative name for a parent. A subsidiary is a separately incorporated entity. And then we might have an agent. That by contract is doing business on behalf of the parent company in that particular country, either because of the local laws require a local company to do work on behalf, or it could be other reasons. They don't want to, the parent company may not want to open a factory, so they go hire a local company that can do manufacturing for them through a contractual basis. So subsidiary, separately organized, branch is an alternative name. An agent is a contractual relationship with a third-party company. All right, so the next term that is used is representative office. Now this basically is a storefront. It's a contact point where interested parties can obtain information about the company, but it does not actually conduct business in and of itself. So this may be a storefront, or it could be a presence at a sales meeting or convention of some type, or it could be a kiosk, like if you're in the airport and you see one of the little kiosks or something. And the idea there is that this is where information can be gathered. Now, with the internet, not quite as relevant as it used to be, but the business itself is not conducted at that location. Now, the reason why that's important, when we talk about different types of taxes that can be imposed on a foreign entity doing business within a country, that may include value-added tax or sales taxes or payroll or other type of employment taxes, or there could be manufacturing extraction taxes. Those taxes may only be come into play if you're actually doing business within that country itself. And so to avoid perhaps those type of taxes, the company may still want to have a presence of some type for marketing purposes, but you don't want it to rise to the level of actually engaging in a sales transaction or a manufacturing transaction, because if that occurs, number one, you may be subject to some type of a tax in that country that otherwise you wouldn't be subject to, or it may be simply a prohibition of law. So a country may allow for companies to have a representative office. They may have staff there, but none of the contracts or anything else are actually finalized within that country. So a country may have, around the world there are various different free ports and free trade areas, business development areas. You see a lot of this in Singapore and China, Dubai, throughout the world. And they may allow foreign corporations to set up an office but not engage in any other type of activity because of their laws. And so this is simply a presence, a storefront, whatever you want to call it, but they're not actually engaged in the actual business. The actual business would be done in some other jurisdiction or location. So for example, maybe we're talking about a manufacturing contract, and we want to have a sales office in a country so that people can come find us, but we actually do the manufacturing in some other location. That way we don't have to pay taxes, we're not subject to employer-employee relationships in that country, or whatever the case may be. So it's different from a branch. It's similar, but the difference between when we use the idea of a representative office is that there's no actual business done there. Whereas a branch, there will be actual business done at that location, be it sales or manufacturing or whatever the case may be. So a representative office would be more like they say, a contact point rather than an actual facility of some type. Okay, next we have the term holding company. So a holding company So when I use the term holding company, that's sort of a generic term that refers to typically some type of a subsidiary that is established, a subsidiary being a separate corporation or LLC, that is established for the sole purpose of owning an asset. And it otherwise does not really engage in any other type of activity. Its sole purpose is to have ownership of perhaps land or equipment, such as a tanker, like an oil tanker ship or an aircraft, or a manufacturing facility or whatever the case may be. So the idea when we use the term holding company is it is an entity as a subsidiary that is established for the sole purpose of owning an asset, such as land or whatever the case is. So it's a subsidiary, but unlike when we use the term subsidiary, a subsidiary may engage in actual business operations, it may own assets, but it also does other type of activities. Whereas a holding company, that term is sort of restricted to the idea of setting up an entity of some type for the sole purpose of owning an asset within that jurisdiction. Now this is done quite commonly. You see it a lot in farming, for example, here domestically, where you have the farmland and then you have the equipment, the tractors and whatnot, and then you have the operations of the farm itself, the plowing and the fertilizing, and you have employees. And oftentimes you will separate the ownership of the land from the operations of the farm. And the reason why that's done, this is really common, we see this all the time here in Oregon. The farmer who owns the land will set up a limited liability company, an LLC, to own the land, and that's the only thing that that LLC does. It just strictly owns the property. And then all the farming activity would be done in a corporation that's owned by the same person. And then they lease the land from their LLC. So the LLC that owns the land would be a form of a holding company. And the reason for that is it separates liability. So on the activities in the farm, if somebody gets injured on the farm or one of the employees runs somebody over with a tractor or something and you get sued, it compartmentalizes and it keeps that land in a separate LLC apart from the farming operation. And so that's one reason why you utilize a holding company, is to maintain ownership of an asset separate from the operational side for liability shielding purposes, but it could also be for tax purposes. The holding company, again, it may own real estate and it would lease it back to the parent company. So essentially you're paying yourself rent, but you do that because lease payments may be subject to a lower level tax than other type of income. So like, for example, here in the United States, when you pay yourself rent, it's not subject to Social Security tax. That saves 15.3% in taxes. So holding company is the generic term that is utilized to refer to an entity that's set up as a subsidiary, but the sole purpose is to own an asset. Now, from an international standpoint, that would be owning a factory or a farm or land in another jurisdiction, or it could be owning, like I talked about earlier, intellectual property such as patents and trademarks for product lines, and the only asset of the holding company would be the patent, the trademark, the copyright, the digital music rights or digital movie rights, sales or distribution rights, whatever the case may be. And the purpose for that is simply to allow for ownership of that asset separate from the other operations of either the parent or one of the subsidiaries. So it may be an LLC, it may be a corporation or other type of business entity in and of itself. And then finally we get to the term joint venture. So a joint venture in and of itself is not an entity or a separate or an organizational structure. It's sort of a name that refers to when two or more companies are working together for a specific purpose, a project, or ongoing business relationship, but they don't want to be considered a partnership. So, for example, maybe the project is going to be to build a high-rise office building or apartment or something, a $1 billion building. And so you have the construction company, you have the owner of the land, you have the architects, you have the companies that are going to set up offices in the building once it's all established. So they don't want to be considered a partnership, because if they're a partnership, they have cross liability with each other. So what they may do is they may establish a joint venture that may be in the form of an LLC that's established for that one particular project, where they all collaborate together on that project, whatever it may be, or it could be an ongoing thing, not just one time, but they clearly set forward that they're doing this as separate entities that are working together, but they're not working together to create a form of a partnership where they have cross liability with each other. And so this term joint venture is sort of a loose term that refers to a collaboration or working together without creating a form of partnership. Now, what do I mean by that? Under US law, this is pretty well true elsewhere as well. When you have people or entities working together, that can create a partnership type relationship as a matter of law. And the problem with that is a partnership can lead to liability for the actions of the other partners. So if we have, let's say it's a concert event, right? Like Lollapalooza or some type of sports event or something, right? So we have Pepsi, we have the location where they're going to hold the concert, you have all the musicians, you have the food vendors. They're all working together to put on this event, but they don't want to be considered partners with each other. And so they essentially may establish an LLC, or if nothing else, they just set forth, this is a joint venture of these completely separate companies working together for this one thing, and it's not intended to create a partnership for either tax purposes or for liability purposes. It may be set up as a separate company in and of itself, where the parent companies own a percentage of it, or it may be set up as an LLC or some other type of entity based in that jurisdiction. So these are the broad terms that we'll be talking about and using, and there are various reasons why you may want to choose one or the other. when you're structuring how to set up a business in a certain location. It may be that you're required by law in that jurisdiction to utilize, you may not be able to set up a subsidiary, the law may require you to do business through an agent. And so that will depend on the law of the jurisdiction where you're talking about setting up a business type activity. Okay, so let's move on a little bit and talk about some of the terms. Page 27, I'm not going to go through every one of these, but this comes out of the textbook. So civil law business forms, common law business forms. So we have in the United States, the most common type of business organizations, of course, are C corporations, S corporations, limited partnerships, and limited liability companies, with limited liability companies becoming more and more popular as time goes on. So we see the same basic overlap or same type of business structures that we are familiar with in the United States. We see those same type of business structures in other countries as well. They go by different names, of course, because of language or just because of how the laws developed. But essentially, if you look at overlap, we see in common law countries and civil law based countries the same basic types of structures. So partnership, which is a collaboration of people or companies that is not a separate entity. It is a working togetherness without a separate, as a partnership. We see corporations, which are also, we find in civil law states. Different kinds of corporations. We may have publicly traded corporations, which may be called a public stock company or other similar name. We have private corporations, which are not publicly traded, which are limited to small issuance of stock. And we have limited liability companies, which go by different names as well, which are a separate type of entity. Now, I want to talk a little bit about some of the different restrictions and whatnot that we see with different countries versus US and how US treats especially LLCs because they're so common now. So let's move over to, where are we? Page 29. So these are some of the reasons and issues that we're going to talk about or that you look at when you're maybe going to set up in a foreign jurisdiction. So first of all, do you want to establish a new entity such as a subsidiary or a holding company? Or do you want it to be more of a branch or representative office? And again, the law of the jurisdiction may dictate that for you because you may not be able to establish a subsidiary, so you have to use a branch office or an agent. Is there a limitation of liability issues that are would dictate setting up a separate entity? So you, like I talked about earlier, compartmentalizing the liability. Do you have any form of entity restrictions, which I'll talk more about in a moment? And then we have the idea of free zones, which we'll talk about on Tuesday more. But these are areas around the world that allow for importation of building materials and component materials tax-free. So perhaps I build laptop computers, I'm Dell Computer, and I want to set up a manufacturing facility, let's say in Costa Rica, and they have, for example, a free zone that allows for my computer company to import chips and hard drives and LCD panels and keyboards into the port area, and then we can assemble those and turn it into a computer, and those component parts are allowed to be brought into the country tax-free. And then I can export them out of that free zone area once the computers are built, again without paying tax. And so that may require under Costa Rican law that we establish a Costa Rican corporation in that area. And these are really common throughout the world, and we'll look at those in a little bit more detail next week. Do you have legal restrictions that may restrict the type of business? So for example, maybe you're going to be in a country that does not allow for alcohol or other type of products, or if they do, it may be limited to a locally produced product. That may impact how you set up your business in terms of a subsidiary versus a branch. What import-export regulations, what sort of taxation might there be? If you set up an entity, you may be subject to a corporate tax, where if you are using an agent, you would not be subject to that level of tax, and so you don't want to be a separate entity, and you might want to be an agent instead. So, one of the type of taxes that we look at down below here is VAT tax. And I want to talk about that for a moment. VAT stands for value added tax. Value added tax. We don't really have this in the United States so much. I've never really seen it in the US. But this is really common in other, especially in Europe. And so the idea of a value added tax is every time, if you take a raw product, let's say wheat, and it's going to be turned into bread. So you have at each stage along the production line value that's added. So we have the wheat that's planted in the ground by the farmer, and then it grows, and then it's harvested. So now you have the raw wheat itself. It hasn't been processed yet, but it went from basically being a seed to wheat product in a raw form. That's value added. And then when you take the wheat kernel and you turn it into flour, you send it to the mill, you're adding value there as well. And so a value added tax is a type of tax that is levied upon the production every time value is added along that chain of production. So it may be that the farmer is subject to a value added tax from turning it from seed into a wheat kernel. You then have value added when that wheat kernel is milled and turned into flour. You then have value that's added when you take that flour to the baker, and the baker turns it into bread. It's then sold at a wholesale level and eventually to retail. So we have 4 or 5 steps in that chain of production. So each one of those steps may be subject to a tax, a value-added tax. And over the course of that all 5 production levels, you have to pay that tax multiple times. Now, why is that important? Well, if you're a company, let's say you're doing farm, you control the whole line of production from when the seed goes in the ground to the point it's sold at a retail level as a bread loaf. So now you've got all these value-added components. Now it may be in the jurisdiction you're in that the value added is only applied to different companies. So if you keep that all within one entity, you only pay value-added tax once at the retail sell. As opposed to, you may have, if you have different companies involved, different farmer, different baker, different flour milling company, each one of those entities is subject to a separate value-added tax. So therefore, it would make sense to bring all of those steps of production into one subsidiary. So that's the kind of thing I'm talking about when you're analyzing how are taxes that are imposed. It may tell you how you want to organize your business structure, or it may be the value-added tax is not imposed on farming if the farming is done by a local company, in which case you'll contract that out. So that's the kind of thing I'm talking about. Same thing with sales taxes. A value-added tax is really just a different type of a sales tax. All right, next page over. I have these all highlighted because these are terms that you can fold into your essay questions. So these are some of the issues we talk about with We talk about some international issues when you're deciding how you may want to organize your business structure. So first of all is the term minimum capitalization requirement. So this is a phrase that refers to the amount of money or value that you must have as a reserve to set up either a corporation or an LLC in a particular country. It's called a minimum cap requirement. So for example, let's say I wanted to set up a form of a corporation in Mexico, and under Mexican law, I'll just show you real quick, you don't need to turn your page. You gotta find the right page. So if I want to set up a Mexican corporation, either a Mexican corporation here, oh, this is the wrong slide, sorry, this slide here. So if I wanted to set up a factory, let's say in Mexico, and I want it to be a separate corporation, one of the issues I look at is what are the minimum capital requirements that must be provided. Now in the United States, for the most part, for small business, we don't really have minimum capitalization laws. Minimum capitalization basically means how much money do you have to hold either in a checking account, a savings account, or it could be a bond, which is an insurance policy, or you may have to deposit money with the government to hold on a reserve as a corporation. And the idea behind a minimum capitalization requirement is the idea that a corporation as a separate entity must maintain a certain level of liquid deposits in order to meet potential debt or other obligations, such as a lawsuit. So in Mexico, they have a minimum capitalization requirement of 50,000 pesos, 20% of which must be paid at the time that you set up the corporation. So it's held in a separate account, and Mexico requires at least 2 shareholders for setting up that corporation. In the United States, we only require 1 shareholder. So there are little nuances and differences between US law on corporations and LLCs and other countries. And of course, that will depend on the country. So the first issue is when we're setting up or looking at setting up another corporation as a subsidiary, do we have a minimum capitalization requirement that we have to meet? Now that's not a whole lot, 50,000 pesos is not a huge amount of money, but it may be several million, or it may be more than that, depending on if you're going to be publicly traded and other type of activities. If you're going to be an insurance company or other fiduciary, you may have to have 20% on reserve, which is a huge amount of dollars that have, or whatever currency that have to be maintained. So that's one of the issues we look at when we're talking about either setting up a subsidiary, using an agent, or just being a branch. Do we have to meet a minimum capitalization requirement, which may be substantial? Most European countries have much higher minimum capitalization requirements that have to be maintained for a corporation. All right, the next issue is, are there laws that limit what are called expatriation of profit? So these are laws that are fairly common, although we're seeing them be reduced quite a bit. These are laws that limit the ability of a foreign corporation or LLC or other entity to remove profits, that is expatriate, take the profits that are made out of business activity within that particular country. And so there may be laws that say that you can only remove X amount of US dollar worth of value each year. You have to keep the balance of the profits within that country in order to maintain the business license to do business there. And so that's something, of course, you want to know about, because it may be, if you're a subsidiary, you're subject to those restrictions on expatriation of profits, whereas if you're using an agent, or you're just doing a representative office where you're not actually doing business there, you don't have that restriction. And so that's another one of the issues you want to look at when you're deciding how you want to set up your structure within that country. Are there foreign ownership restrictions? These are restrictions that are often in place that limit the percentage amount of foreign ownership of either a corporation or an LLC or a business trust or other type of entity. So it may be a flat-out prohibition on ownership of certain sectors of the economy, perhaps prohibition on foreign corporations from owning agricultural land or engaging in manufacturing of certain type of products. Or it could be a flat-out prohibition which may require, the next one here, a local participation. So these are related to each other. So a foreign ownership restriction is any kind of restriction that limits the ability of a foreign corporation to do business within that jurisdiction. And if you do have that type of restriction, then you would be forced to use an agent rather than a subsidiary. Or it may be that the ownership restriction requires local participation. What I mean by that is these are laws that may require a subsidiary, a separately incorporated company in that country, to have a minimum amount of ownership by a local person or a local company. So perhaps you have a law that says if you want to set up a subsidiary as a foreign corporation, you must have at least 20% of the stock owned by a local person or a local company. The other 80% can be owned by a foreign company, in which case you need to team up with either another person or another company in that jurisdiction. Or it could be the other way around. It could be 80% must be owned by a local person or company and only 20% can be owned by a foreign entity. Or it could be, if you're a subsidiary and you're incorporated in that country, even if the subsidiary is owned by a foreign parent, you're not subject to those restrictions. But if you're a foreign parent company and you're going to be a branch, you are subject to them, in which case you want to set up a local corporation because you're not subject to those requirements. Now typically those requirements are, the reason why is one, to maintain the profits within the country so they're taxable, and also to promote local employment. So you don't have foreign companies coming in, doing business and removing all the money without potentially paying tax on it in that local jurisdiction. Limitation of liability and tax differences. These are potential differences between how U.S. treats limited liability versus foreign countries. Governmental examiners. A governmental examiner is, we see this in Mexico, where when you set up a corporation, you also have to hire what amounts to an auditor, which are usually employed by the government, but it could be a private accounting firm. And you have to have them, when you first incorporate, and hire them to essentially look over your books on an annual basis and provide a report back to the government that you're in compliance with whatever rules they have. So it's a form of an audit, and you have to, of course, pay the company, or if it may be an actual government employee, depending on what jurisdiction you're in. You have to pay them, of course, to examine your books. We don't really have that here in the U.S. unless you're publicly traded. Then we do have audit requirements to maintain your SEC, Securities Exchange Commission requirements. And then also at the very bottom here, Sharia or other legal customary issues which may limit, especially under Sharia law, may limit how you establish a business so it's Sharia compliant. So for example, there may be a prohibition on interest, like in a loan. There may be prohibition on use of derivatives like calls and put options, stock options, cryptocurrency transactions, or other type of transactions that are sort of a quasi-gambling kind of a transaction. Those may be prohibited under Sharia, if you're doing business in a Sharia-based legal system, in which case, instead of having like a loan, you would have a partnership type arrangement where the bank, instead of lending money, would become a partner with you in your business activity, maybe a 8% partner instead of an 8% interest rate. There are various different variations of that. So that would be something that would dictate how you organize your business in that location. All right, page 31. So, LLCs, limited liability companies here in the United States, are very common. They're becoming more and more common in the business world. And so these are some of the issues that you look at when we talk about an LLC outside the U.S. versus how we treat them within the United States. So typically, outside the United States, an LLC is treated as a form of a corporation rather than a form of a partnership. In the U.S., an LLC can be treated either as a corporation for tax purposes, which may mean it's subject to a corporate tax, which is pretty uncommon. But usually, an LLC is treated as a partnership, which under U.S. tax law is a flow-through entity, and the money flows down to the owners and then they pay tax. So the LLC itself doesn't pay a corporate income tax. Outside the U.S., most LLCs are treated as a corporation, which means it will be taxable at the entity level. Now, what does that mean in the real world? Well, let's say I'm an LLC set up here in the U.S., and I'm treated as a partnership here, where we don't pay a corporate tax. But now I'm going to be doing business, let's say in Germany, which treats an LLC as a form of a private stock corporation. Not publicly traded, but it's still a corporation. So that means I would then be subject, even though in the US I'm not subject to an income tax, under German law, my LLC is treated as a form of a corporation, in which case I would have to pay income tax in Germany or wherever I happen to be. So that's one of the big differences between the US and other countries, is whether or not the LLC is subject to a corporate type of a tax. And again, most other countries, LLCs are a form of a corporation rather than a partnership like we see in the US. In addition, most LLCs outside the US have a minimum capitalization requirement. So in other words, you have to maintain a minimum dollar or euro or whatever currency level in your LLC that may be held on deposit either in a government account or in a private bank account, but you cannot touch that money. It's basically a reserve. Where we don't have minimum capitalization requirements in the United States unless you're publicly traded. So that's another big difference between LLCs domestically in the US and outside the US. Similarly, most other countries do not allow for a single member LLC, one person. Here in the US, that's a very common form of business activity for one person, rather than being a sole proprietorship where you have no liability protections. You can form a single member LLC. It's probably the most common form of business structure right now I see for small business. But outside the US, many times an LLC must have more than one member. You can't have a one-person LLC. And so that can create problems, of course. If it's just you, you now have to either set up another subsidiary or an agent or have somebody be brought in as a part owner of your LLC. So that may impact your decision on how you want to establish a business presence outside the U.S. So S Corp versus C Corp. An S corporation in the United States is a private corporation, small business limited to 100 shareholders, and it's not a taxable corporation. S corporations, similar to LLCs outside the U.S., are typically going to be treated as a private stock company and subject to a corporate level tax, whereas in the U.S. you would not be. So an S corporation is sort of a purely United States thing under our tax code, and when you get outside the U.S., even though you're an S corp domestically here in the United States, you would be subject to a corporate tax, corporate minimum capitalization requirements, etc. And may not even be recognized in some states. So if you're an S corporation or an LLC here in the U.S., if you're just one person, or depending on what the laws are, they may not even recognize you as a separate entity, which means you would lose your liability protections and that kind of thing, or you may have to form a subsidiary under that law rather than act as a branch or representative office. So just because you're treated one way in the U.S., there's going to be slight or maybe major differences in how that form of structure is treated outside of the United States. Excuse me. Here it is, okay. So, page 37. So here I have a list, and I'm not gonna, my French and German are not the best, but. So this is a list of abbreviations and terms that relate to business structures that you see commonly outside the United States. So Société non collectif, which would be a French civil law partnership. And then you have Société en commandite simple, civil law limited partnership. So the first one would be collective, which would be like a general partnership. The next one would be like a limited partnership that we have here in the United States. In Germany, we would call a limited partnership or a silent partnership Stille Gesellschaft. Stille is silent. Gesellschaft is German for a business endeavor of some type. So again, we have the same kind of basic forms in both French and German law, the same thing in Mexico, where we have the same basic types of forms that we have in the U.S., limited partnerships, general partnerships, but they're of course going to go by different names. And then these are the next two here, partnership limited by shares. That would be similar to what we would call a publicly traded or a partnership that has shares that you can sell that are not necessarily restricted. So it's sort of like a smaller corporation in a way. And then these are the big ones here. An SAA, Société Anonyme, which is the French stock corporation, so that's what you would see publicly traded, or an AG, Aktiengesellschaft, which would be a German. So this would be like a C corporation under US law, these two. And you'll see that quite often in those abbreviations. And then the bottom ones are what amounts to a limited liability company. And you'll see these abbreviations, especially GmbH, which is the German form of an LLC. I think if I remember, Mercedes, the US is a GmbH company. So I highlight these because I do have a test question. I'm not going to make you, write all this out, but I have a test question where I refer to these abbreviations, primarily the bottom ones. So I may ask you, what is a GmbH form of company under German law? And that's where you're going to find the answer. That would be a form of a German limited liability company. And again, they're going to have differences in how LLCs are treated versus the US, in terms of taxes and minimum cap requirements. We're getting some here. All right, I'm not going to go through all the steps in setting up, so